your Minnie Mouse right here.
Hello, sir. That sack right there. You want to take the notes? $16. Are they all the same price?
Yeah, $2.50. What are stickers?
So what happened? Was it you?
Yeah.
What happened?
I took the stickers. I had my wallet out there.
But you walked out of the store?
Yeah, I had to get my wallet.
Unfortunately, in New Jersey, you walk out of the store.
I know. I had to get my wallet.
This case turns on a single legal question of striking simplicity. Does briefly exiting a New Jersey retail store with unpaid merchandise constitute a completed shoplifting offense? Even when the subject claims an intent to return and pay, the answer under New Jersey law is yes. Understanding why requires examining the precise mechanics of the controlling statute. Under New Jersey Statute Annotated Section 2C 2011, subsection B, paragraph 1, shoplifting by carrying away requires 3 elements. First, the purposeful taking or carrying away of merchandise. Second, that the location was a retail mercantile establishment. Third, that the act was committed with the intent to deprive the merchant of the full retail value. The first 2 elements are objective and were established by recorded admissions within seconds. The third element, intent, is where the legal mechanism becomes decisive.
Can I get your first name?
Zoe, Z-O-E-Y.
And last name, please. And your date of birth. And private address.
My current address?
Okay, so this time you'll be placed under arrest.
Under arrest?
For shoplifting.
Can I just pay for them? What happened?
It's
I had to go and get my, I understand, I just had to go and get my wallet. Wait, what happened? Because I took the stickers, I had to come out and get my...
that constitutes shoplifting, walking out of the store.
Wait, what the hell? Because Livy went out of the store? Yeah, I had to get my wallet. Wait, can I just serious? Please?
It's not up to us.
So what do we do?
Can I just pay for them, please?
Like, what are we supposed to do? Like, she just walked right out of the store.
I had to get my wallet. I understand that it was stealing.
I get that, but it's just, it's still shoplifting.
First you told me you didn't have them, and then you said you paid for them, and then you finally paid for them.
Yep, can I just pay for them?
So this time you'll be placed on arrest.
New Jersey lawmakers anticipated that intent would be the most difficult element to prove. Their response was Section 2, C, 2011, subsection D, one of the most powerful evidentiary tools in the state's criminal code. Any person who carries unpurchased merchandise outside the premises is prima facie presumed to have done so with intent to deprive the merchant of value. The phrase, prima facie, carries specific legal weight. Proof of the act alone is sufficient to establish intent. The burden of producing rebuttal evidence then shifts to the defendant. This statutory presumption survived constitutional scrutiny in Carollo v. Supermarkets General Corporation. Decided in 1991, the appellate division held that the presumption does not improperly shift the burden because the state must still prove the physical act beyond a reasonable doubt before the presumption attaches. The gradation of the offense is governed by subsection C of the same statute. Where the full retail value falls below $200, the offense is classified as a disorderly persons offense. At an alleged value of $2.50, this case sits at the lowest possible grade under New Jersey law. The custodial arrest itself raises a Fourth Amendment question that the Supreme Court has already answered. In Atwater v. City of Lago Vista, decided in 2001, the court held that warrantless custodial arrest is constitutionally permissible even for fine-only misdemeanors. provided probable cause exists. New Jersey codifies this authority in subsection E, granting officers warrantless arrest power for any shoplifting offense supported by probable cause. The Fifth Amendment analysis is more nuanced and turns on the line between investigative and custodial questioning. Under Miranda versus Arizona, warnings are required only for custodial interrogation. Under Berkemer versus McCarty, decided in 1984, scene-based investigative questioning is generally non-custodial. Pre-arrest admissions are therefore likely admissible without prior warnings. However, substantive questioning that continued after the formal arrest announcement creates a narrow suppression exposure. The doctrine of consciousness of guilt permits the prosecution to introduce evidence of inconsistent statements as circumstantial proof of intent. The recorded sequence of denial, claim of prior payment, and eventual surrender forms a textbook consciousness of guilt narrative. This compounds the statutory presumption and substantially weakens any future intent-based defense. A critical clarification: the offer to pay after the offense was complete carries no legal effect on the elements. Shoplifting in New Jersey is consummated the moment merchandise crosses the threshold of the establishment without payment. Subsequent willingness to pay may inform prosecutorial discretion, but it does not undo the completed crime.
No.
Turn around first, place your hands behind your back.
I understand that you're saying it's fine, but what do we do because you are my sister? So if I don't know what to do, I will raise hell in this place because you're my sister, so I have to know what we're supposed to do.
Sierra 12 Central.
We just have to know what to do.
Alright, so where and when can we pick her up?
I'll tell you in 1 second. Let me just do the radio real quick. I'm gonna have one adult female in custody. We're gonna transport you into 18th Street.
Where's Timmy at?
Out there on the bench.
So right now,
No, I want to talk to her.
so right now, what we're gonna do is we're gonna bring her back to the station, which is gonna be processed, the whole nine, like
It'll be like an hour,
fingerprints,
2 hours.
mugshots. Yeah, about an hour, 2 hours. And then, do you have your phone with you?
Yeah,
Just that way, because we could hold on to your phone if that's okay. And then when you're done, you could just give them a call, and they could just pick you right up from the station. But it's gonna be about an hour, 2 hours.
It's just crazy.
Are you kidding me?
Important, but alright.
Do you mind if I hold on to your phone?
No offense, like I'm trying to get the hell home. Like we don't live around here.
Book bag
With her
outside?
wallet. She's outside.
She's in the
She's
bathroom.
literally standing right up.
Can we just possibly get her ID too? Because it'll help.
She's in the bathroom.
I know, yeah. Can we get it like before she goes though? Because it will help speed up the process. Instead of searching up her name in the database and everything to prove who she is.
Won't be there. Her name's like a unique name.
So we're gonna go out the front and we're gonna go left.
What do I do about Timmy?
Oh, perfect. You're right here too.
Do you want to wait for my wallet or?
They could walk with us to the street end and then we could get it then. But we're just gonna go to the left. Oh, the car's driving away.
Sorry about her. She's a little dramatic. A little dramatic.
Alright, so at this time we're just gonna have her do a quick search.
I don't have anything on me.
We could do it right in here too.
Anyway.
Here, Diamond, do it. Just do it.
It's okay. I don't. Okay. I'm gonna have you turn around first.
Come with me. Alright, so we're just gonna get to the back. I'm just gonna buckle you up, alright?
Honestly, I just really want to go home. I'm not gonna lie to you. Like,
Well, do you know where the station is?
no idea. We're not from
Okay.
around here
I
at
guess
all.
If you want to write it down.
That's it, her ID.
Yeah. I just gave the other guy the address.
Okay.
835 Central Ave.
Her and
He has all the info.
Okay.
Sorry, Diamond.
No, I.
Okay.
She'll call you when.
But like we said before, it's gonna be about an hour or two.
Okay.
We try to make it as fast as possible, but it really depends on like how fast it takes to write the complaint.
Does she get to call anyone? Like, will she be able to call her mom? I don't know if she will, but
She,
I honestly don't
she
know if
can
she will. But
after.
I don't want to like say something to our mom if she
Yeah.
doesn't want me to. Cause
She can after, and like once we're done processing her, she's gonna get a summons, which will like any information further will be through the courts,
Okay.
and then she'll be free to go.
All right. All right. Thank you.
You got it.
Just gonna undo your seatbelt. We're gonna walk her right to that door. I got it. First.
The arresting officer receives a grade of B. The arrest was lawful. Probable cause was firmly established. And the predicate facts for the statutory presumption were articulated clearly on camera. The grade is held at B because the discretionary alternative of an on-scene complaint summons was neither used nor visibly considered. The subject receives a grade of C+. Physical compliance was full. But voluntary admissions supplied the state with every element of the offense. The department receives a provisional grade of B-. Pending review of summons versus arrest discretion policy, 3 lessons emerge. First, the moment of exit, not the moment of intent to return, is the legally operative moment. Second, the statutory presumption of intent shifts the practical burden onto the defendant, making early silence the single most important available right. Third, inconsistent explanations transform a defensible accident narrative into a consciousness of guilt exhibit that follows the case to trial. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching. And don't forget to check out our second channel, Bodycam Case Analysis, second channel, for even more police interaction and courtroom content.